Mr. Hartung, which file are you on?
Morning, I have Sierra Gibson with Brian Fry and Jeff Elliott with Sam Malaro.
Elliot is in our waiting room if you want to do him right now.
Yep, you can bring him in if you want. Sarah Gibson. All right, so raise your hand if you have a hearing today. You do? What's your name?
Rudy Perez.
All right, so Mr. Perez, I'm just gonna mark that you're in person. So your attorney is John Glazier, and he does go to Judge Olsaver's court first. So it will be a little bit, but hopefully not too long, okay?
All right.
All right, anybody else, or are we all just here to watch? Okay. Just in case that's been waived and there's no hearing, are you all here for the same case? What case is it?
Matt Kaiser,
Say it again?
Matt Kester.
Oh, okay. Yep, okay. Miss Adams, if you have a way, or Mr. Hartung texting Mr. Fry, I do have Sierra in the waiting room. So if he wants to pop in, I can get that taken care of.
Okay, and Judge, also, Matt Coaster is adjourned to December 17th.
December 17.
Yes, Judge.
So that has been adjourned to December 17.
Can I not be rude and ask, like, what did he get adjourned for?
I have no idea. Because that's something the attorney and the prosecutor would have done. I don't adjourn them. They get adjourned by the parties.
That's my ask.
Okay.
Oh,
All
I needed this, thank you.
right, thank you.
Yeah. Kill my son.
Can you not talk loudly in the courtroom, please?
Sorry.
It's okay. You can talk in the hallway. All right, those are all arraignments. And then Mr. Malaro, I'm gonna call the jail, Mr. Malaro, and start lining up your people. So hold on 1 second. It's Mr. Malaro. Is Mr. Malaro. I'll try calling the jail later, Mr. Malaro. All right, this is in the matter of the people of the state of Michigan versus Jeffrey Allen Elliott. We have 4 files, 21-2024, FH and 23-21200FH. Those are violation of probation files. And then we have file number 25-22203FH and 25-22204FH, which are set for pretrial today. I have Douglas Hartung appearing on behalf of the people, and I have Salvatore Malaro appearing on behalf of Mr. Elliott. I have a letter dated November 17 from Darren Coast, our pretrial services coordinator, stating that Mr. Elliott continues to drug test once a week at the center. He has at this point 46 consecutive negative tests, so he is doing exceptionally well. So I'm glad to hear that. Mr. Malaro, how would you like to proceed today?
Your Honor, the one of the cases is an AG case, so I don't know if you wanted to wait for the AG or is Mr. Hartung?
He's here. I'm sorry. Now I have Sarah Brenner appearing on file number 25-22204FH. Good morning, Ms. Brenner.
Very sneaky, very sneaky. Judge, it's my understanding Mr. Elliott is still maintaining his payments and doing well. I'd ask if we could adjourn this an additional time to give Mr. Elliott some more time to get some things squared away.
All right. Any objection, Ms. Brenner?
No, Your Honor, that's correct. He's making consistent headway on that.
All right. Mr. Hartung?
No, I have no objection, Your Honor.
All right, Mr. Malaro, February 4 at 8:30 in the morning.
That'll be fine, Judge.
All right, and you'll do the stipend order to adjourn. Ms. Brenner, can he sign your name with permission?
Yes, thank you.
Mr. Hartung, can he sign your name with permission?
Absolutely.
And Ms. Holly, you were gonna add?
Yeah, Mr. Elliott, I think Mr. Jones had said for you to report today. He wants you to call him instead.
Okay.
Okay, that's it.
Sounds great.
Excellent.
Thank
All
you,
right,
Judge.
we'll do the notice for the probation violation files. All right, very good, thank you. Ms.
Thank you.
Brenner, Ms. Underwood may be down in front of Judge Olsaver. I don't know if you have a file with her down there.
I had one. I was over there. She had waived arraignment, so now I'll wait for her with you, Judge.
Okay, all right.
Thank
Feel
you.
free to text her and harass her to pop back down.
Okay, I will.
Thank you, Judge.
Thank you, Mr. Malaro. Hold on, I'm trying to get the jail to get the rest of your people. Try that again. I have Sierra Gibson and I have Mr. Fry. All right, Ms. Gibson, if you can unmute your device and start your audio, please, or video, I mean.
Can you hear me now, ma'am?
I can hear it, thank you. So this is in the matter of the people of the state of Michigan versus Sierra Gibson, file number 25-22225. FH. I have Douglas Hartung appearing on behalf of the people, and I have Brian Fry appearing on behalf of Ms. Gibson, who is appearing via Zoom. I do have a letter dated November 17 from Darren Coast, our pretrial services coordinator. He said that Ms. Gibson has been doing great with her testing the last 3 months. She hasn't been missing, and she has remained negative. So that's excellent news. So, Mr. Fry, how do you wish to proceed today?
Yes, Your Honor. If we could have an adjournment on this, there's some things I want to talk to Mr. Hartung about. So we would request the adjournment if the court was willing to grant that.
All right, how far out?
Just the next available. Doesn't matter, a month, whatever the court has available.
How about December 17?
That's fine.
Mr. Hartung, any objection?
No objection, Your Honor.
All right, and so I'm gonna set this over for pretrial on December 17th at 8:30 in the morning. Mr. Fry, can you prepare the stipend order to adjourn?
Yes, I can prepare that, Your Honor. Mr.
All
Hartung,
right.
I need your permission.
Yeah, no problem.
All right, excellent. So Ms. Gibson, keep up the good work and we'll see you back on December 17th at 8:30 in the morning, all right?
Yes, ma'am. Thank you.
Thank you.
Thank you.
Hmm. Or nobody is working, I don't know. Hey, this is Judge Anslone. I've been trying to reach transport on the second floor for about a half hour. Is there anything going on or?
I don't think so. I'm not sure, but you're ready to see people?
I'm ready for Gary Bowerman and William Byram.
Okay, I will find them and get them to put them in.
You're awesome. Thank you. Bye. Really only 15 minutes, but okay. All right, Mr. Hubble, let me find you. All right, this, do I have a prosecutor? Mr. Gumtow, are you my prosecutor today?
For which case, Judge?
You, oh, okay, I got Phoebe McClure too. I'm sorry, I didn't see you.
No, I just didn't hear what.
Mitchell, I'm
Yep, that's
Sean
me, Your
Mitchell.
Honor.
Okay. All right, so this is in the matter of the people of the state of Michigan versus Deshaun Kevin Mitchell, file number 25-22397FH. I have Brad Hubble appearing on behalf of Mr. Mitchell and Phoebe McClure appearing on behalf of the people. This is the date and time set for a pretrial conference. In this matter, for the record, Mr. Mitchell is appearing in Mr. Hubble's office with him, I'm assuming. Is that
Yes.
your client next to you? All right.
It is, Your Honor.
So, Mr. Hubble, how would you like to proceed today?
Your Honor, we've reached a resolution with the state, and at this point, my client, I believe you have copies of both the plea agreement and his advice of rights that he has executed. He would be withdrawing his former not guilty plea and entering pleas of guilty to counts 1 and 2.
All right.
And Your Honor, just to add to that plea agreement, we did have a Cobb's evaluation on October 31st. And you did give a Cobb's evaluation to two things. One, 12 months probation, which was within his guidelines. And then you also indicated that if Mr. Mitchell so chose, that you would grant a delayed. Mr. Hubble and I had spoken about the delayed option, and I believe he does not want that, does not want the court to impose a delayed option at this time because that 12 months probation can be transferred to his county of residency in Ohio, and then he would be eligible for expungement at some point on both of these.
Okay. All right. Is that correct, Mr. Hubble?
It is, and I thank the prosecutor for that additional information.
All right. So, Mr. Mitchell, can you raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, so, Mr. Mitchell, because you're sitting kind of farther back from the device, I will need you to speak very clearly for it or loudly for us, all right?
Yes,
Your Honor.
Okay, can you state your full name for the record?
Deshaun Kevin Mitchell.
All right, thank you, sir. Now, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention today to plead guilty to count 1, computers unauthorized access, which carries a maximum penalty of up to 5 years in prison and or a $10,000 fine, and to count 2, computers using to commit a crime, maximum imprisonment of 4 years or more, but less than 10, which carries a maximum penalty of up to 7 years in prison and or a $5,000 fine, with the understanding that there would be no upfront jail. And is that right, Ms. McClure? Is that what we said on the Cobbs? Yes.
It was 12 months probation.
And yeah, no upfront jail and 12 months probation. And then that would be able to be transferred to Lucas County. You live in Lucas County, right?
Yes, Your Honor.
All right, and that would be transferred to where you live in Lucas County. So is it your intention to plead guilty to those 2 counts?
Yes, Your Honor.
All right, are you satisfied with your attorney and the advice that he has given you?
Yes.
Neither the prosecutor, the defendant, or anyone that on the defendant's behalf has discussed any other possible sentence with court, in terms of fines, cost, or any requirements for probation. Is that correct, Mr. Hubble?
It is, Your Honor.
And Ms. McClure?
That's correct. The one thing we did discuss were guidelines, and I believe the guidelines on count 1 are 0 to 12 and on count 2 are 0 to 17, but otherwise nothing's been discussed.
Okay, great. Thank you. And is that correct as far as you're aware, Mr. Mitchell?
Yes, Your Honor.
All right. So, Mr. Mitchell, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, sir?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you would not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms or conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So basically, if you were to violate any term of probation or your bond while we're waiting for sentencing, I could give you a jail term, more probation and so forth, and you wouldn't be able to withdraw your plea. Do you understand that?
Yes, Your Honor.
All right. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I have given to you, sir?
No, Your Honor.
All right, so let me get back to the following information. So, Mr. Mitchell, how do you wish to plead to the charge that on or about May 14 of 2025, it doesn't say a city, but I believe it's City of Adrian. Is that correct, Ms. McClure?
Yeah, sorry about that, Your Honor.
All right, in the City of Adrian in the County of Lenawee, that you did commit the offense listed under count 1, computers unauthorized access. Guilty or not guilty?
Guilty.
And count 2, computers using to commit a crime, maximum imprisonment of 4 years or more, but less than 10 years, guilty or not guilty.
Guilty, Your Honor.
So other than the agreements placed on the record, has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
You understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Hubble?
No, Your Honor.
Mr. McClure?
No, Your Honor.
All right, Mr. Mitchell, has your attorney promised you any particular sentence or estimated what your sentence will be outside of the agreement that we placed on the record?
No, Your Honor.
And is it your own choice to plead guilty?
Yes, Your Honor.
All right, so Mr. Mitchell, on May 14th of 2025, were you in the city of Adrian in the county of Lenawee?
Yes.
All right, so Mr. Hubble, I know this is kind of a convoluted case. Would you like to voir dire your client for the factual basis of count one?
Yes, Your Honor, thank you. Mr. Mitchell, as to count one, unauthorized access of computers, were you in Adrian, Lenawee County on May 14th, 2025?
Yes. Yes.
And as part of your employment, were you in possession of a law enforcement radio that gave you access to the Lenawee County Sheriff Office radio channel?
Yes.
Okay. And did you use that to provide yourself access in your own radio to that same Lenawee County Sheriff Office radio channel?
Yes.
And
And you did not have authority to do that?
No.
And that was in
you gotta
violation?
speak a little bit louder, Mr. Mitchell. Can you repeat that last response?
Yes, Your Honor. And did you use computer to access the radio, Lenawee County Sheriff's radio channel and transfer it to your own radio?
Yes.
And did you have authority to do that?
No. No.
I believe that satisfies it, Your Honor.
All right, Ms. McClure?
I think just one follow-up. Was your purpose in doing this to use the services of the Lenawee County Sheriff's radio? It's either to acquire, alter, damage, delete, destroy, or otherwise use the services of that program.
Yes. Yes.
Okay, people are satisfied.
All right, is that to both counts, Ms. McClure?
Just
Just
count one, but the people are satisfied as to both counts. But my
Okay,
question was
and-
just to count one, sorry.
Yeah, Mr. Hubble, do you feel that you've covered the factual basis for both count one and count two?
I do, Your Honor. They're so closely related, the same process is here. I would ask one further question, I guess, of my client. You didn't have authority to be on this Lenawee County Sheriff's Office radio channel, correct?
I did.
I didn't hear his response.
Excuse me, Your Honor. At the time that you transferred to your own radio, did you have authority to be on the Lenawee County Sheriff's Office radio channel?
No. No.
Okay. Thank you, Your Honor.
Ms. McClure, as to count two, are you satisfied?
Yes, Your Honor.
All right, has court complied with the MCR 6.302 B, C, and D? Ms. McClure,
It has.
Mr. Hubble?
It has, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has, there has been a COBS agreement and discussion with the attorneys But outside of that, this court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I am going to refer this matter to the probation department for a pre-sentence investigation. Mr. Hubble, in light of the fact that there is no upfront jail, you and your client can appear via Zoom if you so choose. My sentencing date is January 9 at 8:15 in the morning. Are you available January 9 at 8:15 in the morning?
Yes, Your Honor.
All right, and do you want to appear via Zoom?
We'll appear in person, Your Honor.
Okay. All right, so I'm going to put you in a breakout room here in a minute with Miss Holly from our probation department to get your contact information and give you some basic instructions, Mr. Mitchell. She's going to advise you that you need to report on a certain date or time and meet with the probation department. When you meet with them, be truthful about your background and the events that occurred. They'll prepare a pre-sentence report. We will provide a copy of it to your attorney, Mr. Hubble. Mr. Hubble will review that with you before the day of sentencing. So, Ms. Holly, I'm going to pop you guys in that breakout room real quick. And then Mr. Hubble and Mr. Mitchell, I don't believe there's anything else, is there?
Nothing, Your Honor. Thank you.
Okay, Ms. McClure?
Nothing else. Thank you.
So, Ms. Holly and Mr. Hubble, let me find you, there you are. Go ahead and join it and you can disconnect when you're done. Okay,
Thank you.
I have a Samsung device. Could you tell me who you are?
Ryan Bates.
All right, I'm gonna rename you. You said Ryan, R-Y-A-N?
Yes, Your Honor.
That one's mine,
BH.
Judge. We're just waiting on Rhonda.
Okay, so Mr. Bates, you are represented by Rhonda Underwood. Miss Underwood typically goes to Judge Olsaver's court first. So I'm gonna pop you back in the waiting room, and as soon as she gets back, I will bring you back in, okay?
Sounds good. Thank you, Your Honor.
Okay, thank you. Hold on, Mr. Malone, 1 second. All right, I just admitted someone on an iPhone. I'm gonna ask you to unmute your device and let me know your name, please. What is your name?
Elisa Palmer.
All right, spell your first name.
Elisa.
Last name.
Palmer, Palmer.
And let me find, let's see here. Miss Palmer, Miss Palmer, I don't have a file for you this morning. What are you here for?
The Attorney General has my case for Jeffrey Elliott.
Okay, so ma'am, we already did that case. Mr. Elliott has been making payments and in compliance, so it was adjourned to, let me find it here.
February 4th, Judge.
February 4th at 8:30 in the morning, Miss Palmer.
Okay, that's fine. Thank you.
Thank you. You have a good day.
You too. Bye-bye.
All right, Mr. Malaro, I have both of your clients. Do you have a specific one you would like to start with?
Judge, we could do Mr. Bowerman.
All right, in the matter of people of the state of Michigan versus, hold on, let me get your files. Gary Bowerman, we have 25-22242FH, 25-22277FH, and 25-22243FH. I have Salvatore Malaro appearing on behalf of Mr. Bowerman, and I don't have a specific prosecutor, so I'm going to go with Mr. Gumto.
If Mr. Bayonetto's there, it's his case. If he's not, then I'll appear.
Okay, Phoebe, so Mr. Seed's not here today, so who's like my pinch hitting
I am, yeah.
prosecutor? Okay,
I
thank
am,
you.
Your Honor.
And
Yeah,
I
no
have
problem.
Phoebe
Sorry about
McClear.
that.
It's okay. I have Phoebe McClear appearing on behalf of the people. So, I have, let me see. I have 3 files today, but I only have 2 on my docket. Okay. Anyway, Mr.
That's
Malaro.
correct, Judge.
Okay. So, Mr. Malaro, how would you like to proceed with Mr. Bowerman today?
Your Honor, Mr. Bowerman has a preliminary exam scheduled for this afternoon on a pending matter. I would ask to adjourn these cases, probably 3 weeks, just in case by some strange coincidences, cases were to be bound upstairs circuit court.
Okay. So my next available is December 17. So Mr. Bowerman, I'm going to adjourn these to December 17 at 8:30 in the morning. Mr. Malaro, do you want all 3 files set for pretrial on December 17 at 8:30?
Yes, please, Judge.
All right, and I have okay, and is that a possession of methamphetamine case that you have downstairs for prelim?
I think it's a malicious destruction of something.
All right, so I have a police report dated November 12. Dated November 12. So hold on a second. We do have a new show cause against him dated November 3rd of 2025 for him testing positive for cocaine and methamphetamine on a drug screen collected November 3rd. Some admission of use, and then there is a police report dated November 12 of 2025. Let's see if I can find, yep, from Mr. Bowerman. So it looks like that would potentially be a violation of bond conditions. Do you want a not guilty plea entered on those and continue to the next hearing?
Yes, Your Honor, we would waive any reading, stand mute, ask the court to enter not guilty plea on those.
Okay, so we will do that. All right, Mr. Bowerman and Mr. Malawi, you do the step in order to adjourn. Ms. McClure, can she please sign your permission?
Yes, you can.
All right, Mr. Bowerman, we'll see you back on that day. Thank you. All right, so then you must be Mr. Byron. So grab your files. In the matter of the people of the state of Michigan versus William Sean Byram, file number 24-21959FH, 24-21960FH, and 24-21961FH. These are all set for pretrial. There is a contempt of court on all of these files because Mr. Malawi, he failed to appear for court on October 23rd of 2024, and I did set them over today for you to be with him. So it has Salvatore Malaro appearing on behalf of Mr. Byram and Phoebe McClure appearing on behalf of the people. Mr. Malaro, how would you like to proceed?
Yeah, if I could do a breakout with Mr. Byram, I'd talk to him about what some of these things.
All right, so Mr. Byram, I am going to open up a breakout room and pop you in there with Mr. Malaro. Just sets and Malaro, okay. Go ahead and join that breakout room. Mr. Murphy, let's see what we can find for you. All right, Johnny Ramos Ruiz. Hi, you want to come up to the podium? Is Isaac Rosales here? Yeah, you come through that gate right there. Yep. No, walk through the gate. Yep, and come up to that microphone. No, you gotta come up here to the microphone. All right, this is in the matter of the people of the state of Michigan versus Johnny Ramos Ruiz. File number 25-22332FH. I have Dan Gunto appearing on behalf of the people and Matt Murphy appearing on behalf of Mr. Ramos Ruiz. So this is the date and time set for a pretrial conference. Mr. Murphy, how would you like to proceed today?
Your Honor, in speaking with Mr. Gumtow this morning and messaging him, there is talks about a no contest plea to a misdemeanor. I was wondering if I could talk to Mr. Ramos Ruiz in a breakout, if he could go out in the hallway briefly, if we could talk.
All right, so I'm gonna walk him out in the hallway and we're gonna connect him to the the Zoom room. So let's walk out there. I don't hear enough connection, right? MIT too. Hold on, Mr. Murphy. All right, I'm gonna send I sent you another request to unmute, so unmute again. There you go, and now I'm gonna send you a request to start your video.
Okay.
Perfect, okay, so now I'm gonna pop you in a breakout room and with Mr. Murphy, and you're gonna get an invitation. So Mr. Ramos Ruiz, you're gonna get an invitation to join a breakout room. So join that breakout room, and then when you're done talking to him, don't even shut that off, just come back in the courtroom, all right?
Okay, thank you.
You're welcome. Join the breakout room. Some other people came in. Does anybody have a case today? What is your name?
Jacob Kelly.
Jacob Kelly. Let me hold on, let me find you. There you go, in person. So Rhonda Underwood is your attorney. She goes to Judge Olsaver first. What's your name? Oh, yep, Mr. Prez, I have you. And sir? All right, let me find you. All right, you're represented by Mr. Glazier. So he goes to Judge Olsaver first too. So he'll be here shortly, all right? So, Mr. Dagger Margosian, I have you down for Daniel Norden. Come back up here. Come back up here. Mr. Dagger Margosian, you have Daniel Norden.
Yes, Your Honor.
Do you know where he is?
I've tried to contact him. I wasn't able to make contact.
Right. In the matter of the people of the state of Michigan versus Daniel Philip Norden, file number 25-22453FH. I have Michael Dagger Margosian appearing on behalf of Daniel Norden, and I have Phoebe McClure appearing on behalf of the people. Mr. Norden was set for arraignment at 8:15 this morning. Mr. Norden has failed to appear. Counsel did reach out and try to contact him, wasn't able to do so. I'm going to issue a bench warrant for failure to appear. And I will set bond at 50,000 cash. Obviously, we don't sign these bench warrants for 48 hours. Mr. Dagger Margosian, if you are able to reach him, just let us know and I'll bring him in right away. All right.
Will do. Thank you, Your Honor.
And Mr. Dagger Margosian, I don't think I had anything else with you, did I?
That's it.
Right, you're not gonna cover from Mr. Glazier?
I'm happy to. I think that has been coordinated, but I'll stick around just in case.
I'm just kidding, you can go. All
right.
right, so, Mr. Ramos Ruiz, Mr. Murphy, you had a chance to speak with them.
Yes, Your Honor.
What would you
So,
like to?
Your Honor, the what I was going to ask, there is a jury trial set for December 10th. At this time,
Sure.
we're going to ask. I spoke with Mr. Gumtow this morning as well about this. We're going to ask to remove that jury trial, have another pretrial schedule on this date. I need to speak to Mr. Gumtow further about the details of the plea, and then talk to Mr. Ramos Ruiz about the details of it and see if that's going to be a resolution we can do short of again having that jury trial. With Mr. Ramos Ruiz being out of custody and him doing well on bond, I don't think there should be any issue with, again, removing that jury trial date. He's obviously going to be available whenever the court schedules another jury trial if we need to. But I think another pretrial will be more appropriate. I think we may have it resolved short of trial.
And you agree with that, Mr. Gumtow?
Yes, Your Honor.
All right, so we will remove the December 10 jury trial. Thank you. And then how far out? I have the next available pretrial would be January 7 now. Now, what I would say is I can set the pretrial for January 7, but if you resolve it, just call and I'll get you in right away to put the plea on the record.
That's what I was going to ask, Your Honor, because if we do have this worked out, I don't want to wait any longer than we need to have
I
him.
always accommodate attorneys. So,
Thank you, Your Honor.
Mr. Murphy, you can do the stip, but I'm going to do the notice of hearing because he's here today. So, Mr. Ramos Ruiz, my assistant's going to bring a notice of hearing for January 7 at 8:30 in the morning. Your attorney and Mr. Gumtow are trying to work out a plea offer. If you decide to take it, Mr. Murphy will get you in sooner, okay? Just listen to what Mr. Murphy says, all right? So have a seat right behind you. Yep, right there. And then my assistant will bring you a notice, okay? All right, thank you. All right, Mr. Malaro, you have Mr. Byram. Let me find judging. You have Mr. Byram. Have you had ample time to speak with him?
I have, Your Honor.
All right, and how would you like to proceed today?
Judge, I would ask the court to indulge me with a short continuance or adjournment, of 2 weeks. Mr. Byram has numerous files, both here in circuit and district court. But I think in that short time frame, I can get these matters in a position for resolution. So that would be my
All right.
request for the court.
Okay, so I will set all of these, Mr. Byram, over to December 3rd at 8:30 in the morning. And Mr. Malaro, you'll do the notice of hearing or step into order to adjourn for all of these.
I will, Your Honor.
And then Ms. McClure, can he sign your name with permission?
Yes, and I just wanted to place on record that there was an offer on all the files made back in October before the absconding. So if Mr. Malaro wants to touch base with Mr. Sneed before then, that's who would be handling these going forward.
Thank you.
To see if that offer is still available.
Yep, duly noted, and we will try to get that done by the 3rd, Your Honor.
All right, so Mr. Byram, we'll see you back. Thank you, Mr. Malaro.
Yep, thank you, Mrs. McClure.
Yep. Was that December 3rd? I'm sorry, Your Honor.
December 3rd at 8:30 in the morning. Okay.
Thank you, Your
All
Honor.
right. Thank you.
Your Honor, if I may,
Yes, you may.
I am covering some matters for Mr. Glazer this morning, a Canablo, an Overton, and a Perez.
All right. Awesome. See if transport answers.
Yes.
Good morning. This is Judge Anslone. I am ready for Mr. Overton.
Already.
Thank you.
No problem.
Bye. All right, Mr. Knaploff, if you want to come up to the podium. Yep, and you just stand right in front of that microphone. So this is in the matter of the people of the state of Michigan versus Daniel Mark Knoblaw, file number 25-22389FH. I have today Salvatore Malaro appearing on behalf of Mr. Knoblaw, and I have Phoebe McClure appearing on behalf of the people. So Mr. Malaro, your video's off and you're muted. So how would you like to proceed today on behalf of Mr. Knoblaw?
Your Honor, Mr. Glazer has a note in the file about a plea offer. If I could perhaps talk to him out in the hall, we maybe can get a plea on.
So Mr. Knoblaw, I'm gonna have you go out in the hallway. Okay, it's already hooked up, we're good. So I'm gonna send you a request to join a breakout room. So when you get out there, you'll get a request to join the breakout room, and all you gotta do is click on join. Oh, my bailiff will walk you out, okay. So, let me, follow my bailiff, yep. I'm going to assign both of those to the breakout room.
It'll ask you to join.
All right, and then I'm gonna send the request to join. So click on join the breakout room. When you're done, just come back in the courtroom.
Thank you, Judge.
Thank you. There he goes. All right. Are you Mr. Overton?
Yes,
All right, Mr. Overton, I'll just be a minute, okay?
yes.
Mr. Murphy?
Yes, Your Honor.
What do you have?
Isaac Rosales.
Okay. Is Isaac Rosales here? All right, in the matter of the people of the state of Michigan versus Isaac Jacob Rosales, file number 25-22346FH. And Matthew Murphy appearing on behalf of Mr. Rosales, and I have Phoebe McClure appearing on behalf of the people. This matter was set for pretrial at 8:30 in the morning, and it is now 9:06. The plea offer was plead to 2 counts of R&O. Mr. Rosales has failed to appear. Mr. Murphy?
Your Honor, I'm kind of confused by his lack of appearance. I spoke with him recently. He wanted me to set trial ultimately in the matter. He does have a pretrial for a misdemeanor tomorrow at 8:30. You know, that may be the reason why he's missing today, but I'd ask for Your Honor to maybe hold off on doing a bench warrant. Give me 48 hours, try to contact him and see. You know, I spoke with Mr. Baronetto about this. If we were to set a trial, it'll be a 4 or 5 day trial, so I don't want to do that until we have confirmation he's
4 to 5 day on R&Os.
A 4 to 5. There's a lot more than just R&O, Your Honor. It's felonious assault and a bunch of other things.
All right. So, Mr. Murphy, I'm going to set it over to next week, or
Thank you, Your
well,
Honor.
not next week, November 26th for pretrial, because I do have notes in the file that he has appeared because we've given him a notice in person. But any objection to that, Ms. McClure, setting it over to November 26th?
No objection, but I did want to make a record that he has failed to appear before. He's failed to appear at the Forensic Center for a competency evaluation, and he's failed to appear in district court before.
All right, so Mr. Murphy, then I am going to issue a bench warrant for failure to appear. But like I said, if he shows up tomorrow, I'll quash it and set a pretrial, all right?
Thank you, Your Honor.
And I'll set bond in the amount of 25,000 cash.
Mr. Murphy, did you still want us to try and get the transcript of the waiver of exam?
I think we already got that. I've already got that because I think
right.
I talked to Mr. Baronetto. He's reviewed it already, and there was nothing to be had
Okay,
about
got it.
Thank you.
All right, thank you both. I think that's all you had, Mr. Murphy.
Yeah, that's all that I have, but I'll be around in case, I know Mr. Millar was covering for Mr. Glazier, but if there's any need, I'll be around in or Judge Olsaber's courts. Thank you, Your Honor.
Okay, thank you. All right, Mr. Millar, we are back on the record with Mr. Knoblaw. Have you had ample time to speak with them?
I have, Your Honor.
And how would you like to proceed?
Your Honor, I think Mr. Canablo would like a little more clarification on the plea agreement from Mr. Glazer. So I'd ask to adjourn this out just a couple of weeks.
Okay, I don't have any notes on that. So is there a plea offer, Ms. McClure? Because I just want to keep a note in my file.
Yeah, and as far as I can tell from the notes, Mr. Glazier indicated to Mr. Sneed that he was good with the plea. It was a domestic violence under 7694A.
That's correct, but Mr. Canablo doesn't know me and he's more comfortable with Mr. Glazer.
All right.
No,
so
that's fine. I just, yeah.
A domestic violence first offense.
Yes.
All right. So Mr. Knoblaw, reach out and set up an appointment to meet with your attorney. The plea offer is to a 93-day domestic violence first offense. And then under the statute 769.4A, you successfully complete probation, it gets removed from your record. Is that correct, Ms. McClure?
It is.
Okay. So make sure you call Mr. Glazier's office and you set an appointment with them. I'm going to set this over to Ms. Adams. If I could get a notice of hearing, I'm going to set this over to December 17 at 8 a.m. So Ms. Adams, if I could get a notice of hearing for him.
And that's 8 a.m., Judge?
I'm sorry, 8:30. So December 17 at 8:30. So have a seat right behind you and we'll get you a notice of hearing and then make sure you schedule an appointment with Mr. Glazier, all right? All right, thank you.
Judge,
Okay.
I'm sorry. Who was that last one that didn't show? I missed it.
Mr. Rosales.
Rosales?
Okay.
Rosales.
All right. Thank you.
All right, so we are back on the record, Mr. Malaro, or I'm sorry, now I'm gonna call Mr. Overton. So this is in the matter of DeMonte Overton, file number 25-22450, FH 25-22451, FH, and 25-22452, FH. Mr. Malaro is covering for Mr. Glazier on this file, and I have Phoebe McClure appearing on behalf of the people. Mr. Malaro, just for your information, Mr. Overton does have a holder with no bond from Wayne County for charges of bringing weapons into a prison or jail. And they have notified us they do plan to pick them up. So I just wanted to give you that updated information. So Mr. Malaro, how would you like to proceed with Mr. Overton?
Judge, Mr. Glazer's note indicates there's a plea to be put on the record. If I could do a breakout just to make sure we're on the same page with that with Mr. Overton.
Okay, what is the plea offer?
John's notes say plead to 2 counts of false pretense, count 2 on each file. There's a Killebrew to 90 days in jail. And somewhere in here is the written plea offer.
And if eligible, we had no objection to Haida. If he is eligible, I guess I don't know his age.
Oh, yeah, it says no objection to Haida.
And then the plea had to be on the 2 cases where the most money was taken.
And yeah,
We
there's
have the file numbers.
Yes.
Just the last 2 numbers is good.
450 FH and 452 FH.
50 and 52. All right, so Mr. Overton, I'm gonna put you in a breakout room with Mr. Malaro. And then he is going to go through the plea offer with you. He is also with our public defender's office. And so he works with your current attorney. So I'm gonna open up that breakout room and go ahead and join it. And then when you're done, I'll bring you back, okay?
All right.
All right, Miss Brenner, I have Rhonda Underwood. Ryan Bates?
Yay.
Okay. All right, so in the matter of, let me bring Mr. Bates in because he has been here. Okay. All right, Mr. Bates, if you want to go ahead and start your video, please.
Okay. Just a moment. There we go.
Perfect. Want to take your hat off?
Yes.
Only it's still court, we're just virtual. All right, so this is in the matter of the people of the state of Michigan versus Ryan Matthew Bates, file number 25-22336FH. I have Rhonda Underwood appearing on behalf of Mr. Bates and Sarah Brenner appearing as the Assistant Attorney General. This is a date time set for a pretrial conference. Ms. Underwood, how would you like to proceed today?
I've talked with Ms. Brenner. Mr. Bates is making good payments, chugging along. So we would ask for probably 60 to 90-day adjournment in this matter, Your Honor, and I would be happy to do the stipulation in order.
Ms. Brenner, any objection?
No objection, Your Honor.
All right, so I'm gonna set this over to February 4 at 8:30 in the morning for a pretrial. Ms. Underwood will do the stip in order to adjourn, and Ms. Brenner, any objection to her signing your name?
No objection, thank you.
So, Mr. Bates, I am seeing more and more people, which makes me glad, paying down their arrearages and even paying these off. It can be done, which I try to tell people all the time, you know, they get a second job, whatever it is, they pay this down. So I'm glad to see you're making progress. Keep up the good work. And we will see you back on February 4 at 8:30 in the morning. All right, sir?
Thank you, Your Honor.
All right, thank you. Have a good day. Ms. Brenner,
too.
good to
Thank
see
you
you.
very much,
Good to see
Ms.
you,
Brenner, for your patience.
Thanks, Rhonda. That's fine. Thanks, Rhonda. Thanks, Judge.
Thank you.
Thank you. So, that's Overton. All right, Ms. Underwood, let's see what we got. That one. All right, Jacob Kelly, want to come up to the podium? All right, this is in the matter of the people of the state of Michigan versus Jacob Dean Kelly, file number 21287FH, 24-21801FH. Those are both probation violation files. So, Ms. Underwood, how would you like to proceed today on behalf of Mr. Kelly?
Thank you, Your Honor. Mr. Kelly, I've spoken with Ms. Holly. Mr. Kelly did make a payment. Ms. Holly has no objection to this being adjourned, Your Honor. I would ask for an adjournment in this matter, maybe a month or so.
About January 7.
That sounds great, Your Honor.
All right, and no objection to that, Ms. Holly?
No, ma'am. Thank you.
All right, Ms. Adams, could I get a notice of hearing from Mr. Kelly for January 7 at 8:30 in the morning? All right, so Mr. Kelly, have a seat right behind you, and my assistant will bring in a notice of hearing. Thank you. All right, Ms. Underwood, Ms. Underwood. Well, Ms. Underwood, we have Amir Norman. I think that's your last one, right?
Yes. And I was wondering if we had an update as to whether he is still in the Wausau County Jail.
Well, I got somebody on, just popped in on a Motorola, so let's see who it is.
Judge, I also want to weigh in on Mr. Norman. I know it's not a pretrial necessarily, but I just want some clarification on that one, I guess.
Hold on, Ms. McClure, 1 second, because this might be him. So I have somebody on a Motorola device. Could you unmute your device and give me your name, please?
I'm Daniel Philip Norden.
Say it again.
Daniel Philip Norden.
All right, hold on, Mr. Norton.
Yes, ma'am.
I think we just called his
Yep,
Uh,
so Rhonda, could you text Michael Dagger Margosian and tell him his client, Mr. Norden, is here? I don't have his cell phone number.
I will text him, Your Honor.
Or, I know you guys have his cell phone number, but I do not. Mr. Norden, I'm gonna pop you in the waiting room.
Okay.
So don't disconnect, okay?
I won't, I'll stand by.
Okay, thank you. Okay. So in the matter of people of the state of Michigan versus Amir Keyshawn Norman, file number 25-21913FH. Do you know if he's still in jail somewhere? Okay, so Ms. Underwood, you believe he's in Washtenaw County Jail. Have you been able to verify that?
No, it's Wausau County, and I believe it's in Wisconsin somewhere, Your Honor. I believe Mr. Moore confirmed that the last time. I've reached out to Mr. Moore, trying to ask if he's still there, but I haven't received a response from Mr. Moore.
All right, and Mr. Coast said last time he appeared, he was in a Wisconsin jail. So now, Ms. McClure, you can go.
yes, he was released on November 6th, and he was supposed to be going back to Kalamazoo, where he lives. So as far as we know, he's no longer incarcerated in Wisconsin as of November 6th.
Okay, so how about we do this? Ms. Underwood, it looks like he's not in jail anymore. And you don't have a contact number for him, correct?
Correct. I know we said that last time that he wasn't in jail anymore, Your Honor, and he ended up being in jail. So
No, the last time he was in jail, and there is a note of that.
And, so.
How did you, well, I guess, Ms. McClure, how did you get the information he was released?
Okay.
Let me look.
Mr. Coast, do you have any information?
Oh, it was
Judge, I did have an updated phone number and I just tried calling it and that number's been disconnected.
Have you heard from him since he's been released from the jail?
I have not. No.
He does have pending charges in Virginia, Pennsylvania, and Florida, so it's possible he's in any of those states.
So Ms. Underwood, I think for purposes of keeping it clean, I am just going to issue a bench warrant. So if he is in jail somewhere, we might be able to catch him. If he's not.
All right, Your Honor.
All right, so Mr. Norman was ordered to appear today. He's failed to do so. We have a contempt court on him anyway. So I'm going to issue a bench warrant for failure to appear. I'll set bond in the amount of $50,000 cash. Obviously, Ms. Underwood, if you hear from him, I would be more than happy to see him at any time he can pop in. All right.
Thank you.
Thank you, Judge.
All right. Thank you.
I believe that's all I have with you.
Judge,
Okay.
on Mr. Norman, the only thing I wanted clarification of is, has he, so he's pled, and we put out his sentencing because of all these other cases. So what is it that he was up for today? Was it a pretrial on a contempt?
It was contempt pretrial, yeah. Well,
Okay, all right, I just wanted.
Well, I had a letter from Darren Coast that said that he hasn't made any payments, but obviously if he's been in jail everywhere, that's why he didn't make any payments.
But I
And
think the
Judge,
only
he's
reason.
out of jail for much of that time, and thus far he's only paid $50, and his balance remains $27.20.
Okay.
And I think the only reason we put out his sentencing was because of his other pending cases. I thought the court's intention was still to place him on height of probation.
Well, I don't have him. I don't have him to do anything, so we'll see what happens.
I know, I just wanted to clarify what was on the, for the register of actions. Like, I just didn't know what it was up for.
I have contempt and pretrial, so.
Okay.
All right. Thank you all. I have hold on a second. I'm gonna try to fix my screen. So if I lose you guys, Task manager is not, oh, there it is.
Thank you, Your Honor.
Thank you. I did something on my screen. I don't know what I did. Oh, I fixed it. Okay. All right, Mr. Malaro, we are back with Mr. Overton. Have you had an opportunity to speak with them? You're muted. Yep.
I have, Your Honor.
All right, it looks like he is set for arraignment today on all three of these files. Do you waive the reading of the felony information?
Your Honor, we would acknowledge receipt of the information, waive the reading in open court, waive any defects as a time and place and manner of service. It is my understanding a plea agreement has been reached on all files.
Okay, so plea agreement, as Ms. McClure stated, would be that he would plead guilty to count 2 on file number 25-22450FH. Count 2 is false pretenses, 1,000 or more, but less than 20, which carries a maximum penalty of up to 5 years in prison and or a $10,000 fine or 3 times the value of the money or property involved, whichever is greater. And then on count 1 would be dismissed, as well as count 3 at the time of sentencing. On file number 25-22452FH, he would plead guilty to count 2, false pretenses, 1,000 or more, but less than 20,000. Again, carries a maximum penalty of up to 5 years in prison and or a $10,000 fine or 3 times the value of the money or property involved, whichever is greater. Count 1 and 3 would be dismissed at the time of sentencing, and the charges on count 20 or on file number 25-22451FH would be dismissed at the time of sentencing. Restitution would be determined evidently on these files, and if he is eligible, he could be sentenced under the Holmes Youthful Training Act, and then there would be a 90-day jail term and or possibly probation, depending, because he's got those charges in Wayne County. So, Ms. McClure, is that a correct recitation of the plea?
It is.
And Mr. Malaro, how would your client like to proceed today?
Judge, he would avail himself of that plea, but it's my understanding that restitution's been determined to be $7,054.95 to Dollar General.
And $7,054 and what?
95 cents.
Okay, all right. So, all right. So, Mr. Overton, want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Can you state your full name for the record for me, please?
DeMonte Ladre Overton.
All right. So, Mr. Overton, you have heard, you can put your hand down. You have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty on file number 25-22450 and 25-22452 to count 2 false pretenses, 1,000 or more, but less than $20,000? Is it your intention to plead guilty to that count on both of those files?
Yes, Your Honor.
All right. Are you satisfied with your attorney and the advice that he has given you?
Yes, Your Honor.
All right. And neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence than the agreement that he would serve 90 days in jail, and if eligible, he could be sentenced under the Holmes Youthful Training Act. Is that correct, Mr. Malaro?
That's my understanding, Judge.
And Ms. McClure?
Yes, Your Honor.
And Mr. Overton, is that correct as far as you're aware?
Yes, Your Honor.
if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, have witnesses against you appear at your trial to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
All right. Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation? You will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. Do you understand that? So in your case, if you were to catch a new charge while you're in custody, your agreement would go out the window and you wouldn't have any right to withdraw your plea. Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. All right, I'm going to pause. Mr. Dagger Margosian, were you going to be taking a plea on Mr. Norden today or adjourning it?
Attorney, is he in court?
I got him. He
Okay.
logged in. I just didn't know if you're getting another pretrial date. If you are, I'll pause in my plea and do that for you. If you're taking a plea on him, I can take it next then.
It will be a plea. I mean, I should talk with him just to confirm, but the
Yep.
intention was
All
to take
right,
a
so
plea.
I'm going to let him in and I will pop you guys in a breakout room. How's that?
Thank
All right, he's joining. All right, Mr. Norden, I am going to place you in a breakout room with your attorney. So go ahead and join that breakout room, all right?
Okay. Let me look for it.
Say it again.
What for me, my passcode came up.
I can't hear you. Did you get an invitation to join the breakout room?
Hang on. Not yet. You hear me?
Okay. I can hear you. It's kind of sketchy though. Like I can't hear you great. But hold on a second. It's okay. Hold on a minute and let me reopen the room, and then something should pop up on your screen, Mr. Norden, to join the breakout. So I'm going to invite you to join the breakout room. Look on your screen.
Yep. Join.
Perfect. Okay. All right. So, Mr. Overton, do you have any questions about the rights that I've just given you?
No, Your Honor.
All right. So we're going to start with file number 25-22450FH. So, Mr. Overton, how do you wish to plead to the charge that on or about April 8 of 2025 that you were in the city of Adrian in the county of Lenawee, and that you committed the offense under count 2, false pretenses, 1,000 or more, but less than 20,000. Guilty or not guilty?
Guilty, Your Honor.
Okay. And then I'm going to move on to file number 25-22452FH. Mr. Overton, how do you plead to the charge on that file that again on April 8th of 25 in Raisin Township in the county of Lenawee, that you did commit the offense listed under count 2, false pretenses, 1,000 or more, but less than $20,000. Guilty or not guilty?
Guilty, Your Honor.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to these charges?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro
No, Your Honor.
and Ms. McClure?
None, Your Honor.
All right, other than the agreement that was placed on the record, Mr. Overton, has your attorney promised you any other particular sentence or estimated what your sentence will be?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
All right, so Mr. Overton, we're gonna start on file number 25-22450FH. So hold on a second. All right, Mr. Malaro, do you want to voir dire on this? Because I'm not gleaning enough from the felony information. So, Mr. Overton, on April 8th of 2025, were you in the city of Adrian in the county of Lenawee?
Yes, Your Honor.
All right, and then Mr. Malaro, can you do the 5-0 voir dire, please? I'm not quite sure.
All right. So, Mr. Overton, is it true that on or about April 8th of 2025, you were in the city of Adrian, county of Lenawee?
Yes, Your Honor. I mean, yes.
Yeah, don't do that to me.
Sorry.
And did you, with intent to defraud Dollar General in a value of more than 1,000 but less than 20,000, defraud them of items of value?
Yes, Your Honor. I mean, yes. I keep saying that.
And specifically, the amount was $7,054.95, or in the aggregate, it came up to that amount.
Yes.
Give me a second, Your Honor.
Was it a?
So you use some, Mr. Overton, what you did, you used some tactics to manipulate the payment system and obtain gift cards by false pretenses. Is that what you're doing?
Yes.
And you didn't pay for those gift cards?
No.
And you knew that you were not paying for those gift cards?
Yes.
And you did this along with several other persons in conjunction. So you coordinated doing this with some other people?
Yes, correct. I was with other people.
Okay. And you benefited from this obtaining these gift cards under false pretenses? You benefited from that?
Yes.
Since I'm not really familiar with the case, Judge, is the court in the state satisfied with that?
Ms. McClure, anything to add?
Mr. Overton, was the device you used, was it on a cell phone?
Yes.
And it was that same either app or device that you used at multiple other stores?
Yes.
Okay, the people are satisfied.
So was it like Google Pay or Apple Pay or something?
Apple Pay.
Got it. Okay. All right. And then Mr. Malaro, that would be for 25-2240. Based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on April 8th of 2025 in the city of Adrian in the county of Lenawee, that the defendant did commit the offense of false pretenses, $1,000 or more, but less than $20,000 by using a false device, an Apple Pay, to purchase gift cards from, you said Dollar General?
Yes.
And with the intent to defraud Dollar General of the value of that. Anything to add to that, Ms. McClure?
No, Your Honor.
And therefore the court accepts the no contest plea on that file. So I'm assuming it's the same factual basis, Mr. Malone. So you may proceed on 25-22452. And in that case, Mr. Overton, on April 8th of 25, were you in Raisin Township in the county of Lenawee?
Yes.
Was that a Dollar General?
Yes, Your Honor.
All right, so I will tell you, Miss McClure, that, okay, so there's the racketeering for 2 offenses. Okay, never mind. So, Mr. Malaro, you may proceed.
Sure. So, Mr. Overton, is it true that on or about April 8th of 2025, you were in the state of Michigan, County of Lenawee, in Raisin Township?
Yes.
And on that date, on the Dollar General on Occidental Highway, you and some other compatriots had the store clerk activate some gift cards,
Yes.
and you employed some kind of scheme or plan to get the clerk to activate these gift cards and then provided an invalid credit card to get them activated.
Yes.
And after the cards had been activated, this was done under false pretenses. Is that correct?
Yes.
And it looks like this was about approximately $2,600 added to these gift cards through this plan that you had.
Yes.
And you knew what you're doing was fraudulent. You're using a financial transaction device to obtain these items under false pretenses.
Yes.
And you benefited from the use of this fraudulent devices to obtain these gift cards.
Yes.
Is the court and the state satisfied?
Ms. McClure?
People are satisfied.
All right, so based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on April 8th of 2025 in Raisin Township in the county of Lenawee, that the defendant did use with the intent to defraud or cheat the Apple Pay device to activate gift cards. And the value on both of these files was more than $1,000, but less than $20,000. And therefore the court does accept the plea. Has the court complied with MCR 6.302 B, C, and D? Mr. Malaro?
I believe the court has, Your Honor.
Ms. McClure?
Yes, Your Honor.
All right, as I said, I accept the plea. It's been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the plea that was placed on the record. I'm going to refer this matter to the probation department for a pre-sentence investigation. I will set this matter for sentencing on January 9 at 8:15 in the morning. Mr. Overton, you do have the right to be present in person for sentencing, but you can appear via Zoom. Which would you prefer?
In person.
All right, so we will set that sentencing in person. So someone from the probation department is going to come over and meet with you. They're going to talk to you about your background and the events that occurred. Be truthful with them about that. They will prepare a pre-sentence report. We will provide that to your attorney. He will review that with you before the day of sentencing, and then we will see you back on January 9 at 8:15 in the morning. All right, Mr. Overton?
Yes.
All right, thank you.
Is that total restitution 7,000 or is it plus 2,600? Or don't we know?
There's 7 on the one case, the 26 is on the other case, and then the third case, Mr. Sneed will have to get that to you.
Okay.
Well,
All right, thank you.
according to the plea agreement, that number was specific. I believe for all 3 cases.
Mr. Norton, can you
$7,000
just be quiet for a minute?
$7,054.95.
I guess I'd just ask Mr. Sneed to confirm that. I don't know. Yeah.
All right.
I mean, that's what's written down on my guess is it's probably divided amongst the defendants.
Okay.
I don't know.
All right. So we will see you back, Mr. Overton. Thank you.
All right, thank you.
Okay. So, are you going to handle Mr. Perez, Mr. Malaro?
Yes, I am, Your Honor.
All right, Mr. Perez, you want to come up to the podium, please?
Met court. Huh?
Mr. Norton, you got to be quiet.
I'm sorry.
Okay, don't speak and don't let anybody else speak. All right, in the matter of the people of the state of Michigan versus Rudy Mario Perez, file number 25-22457FC. This is the date and time set for arraignment in this matter. Mr. Malaro, do you waive the reading of the felony information?
Your Honor, yes, at this time, we would acknowledge receipt of the arraignment, waive its information, waive its reading in open court, waive any defects as the time and place of service. Mr. Perez would plead not guilty and ask the court set a pretrial in the matter. According to Mr. Glazer's notes, 3 to 4 weeks if the court is willing to indulge that request.
All right, so the court will enter a plea of not guilty on behalf of Mr. Perez. Mr. Malaro, because of the volume of cases being set over, I don't have anything until January 7. So we'll set it for pretrial on January 7 at 8:30. Miss Adams, could I get a notice of hearing from Mr. Perez?
Yes, Judge.
Right, Mr. Perez, have a seat right behind you. And then my assistant will bring in notice of hearing. Thank you.
Thank you.
So, Mr. Malaro, I think that, let me look. I don't think I have anything else with you or with Mr. Glazier. Except, no, I think I'm done with you.
All right. Thank you, Your Honor. Have a good day.
You too. Thanks for helping out today, Mr. Malaro, with Mr. Glazier.
problem.
Thank you. All right, Mr. Dagger Margosian, I have Mr. Norton. So, Mr. Norton, I want to send you an invitation to start your video if you can.
Yep.
Clear.
Okay, Mr. Norton, thank you. All right, on the matter of the people of the state of Michigan versus Daniel Philip Norton, file number 25-22453FH. This is Mr. Dagger Margosian represents Mr. Norton, and we have Phoebe McClure appearing today on behalf of the people. Mr. Norton, I will quash the bench warrant. And how would you like to proceed today, Mr. Dagger Margosian?
Your Honor, in district court, we waived the preliminary exam. After I spoke with Mr. Sears, we reached an agreement. Mr. Norton will be entering a plea today. I can recite the plea for the court.
Actually, I apologize. It's an arraignment. Do you waive the reading of the felony information?
For arraignment purposes, yes, Your Honor.
Okay, very good. So Mr. Norton will be entering a plea. So let me get a Post-it now. That's how I live. What is the plea offer, Mr. Dagger Margosian?
Your Honor, Mr. Norton has 3 files total, 1 felony case, which is the instant case today, and then 2 misdemeanors. So the plea, the overall plea is that Mr. Norton on 25-22453, the one that Your Honor has this morning. He'll be entering a plea to retail fraud, first degree. Count one count of R&O. And in exchange,
Well, hold on. So there's police officer, first responder, assaulting, resisting, and obstructing. So he's gonna plead to that count 2.
correct. He'll plead guilty to count 1 and count 2.
Okay.
And then in exchange, counts 3 and 4 on this case will be dismissed, as well as the 2 misdemeanor cases that exist in district court. There is a sentencing agreement for no upfront jail, and there's a sentencing agreement that he admit restitution on all 3 of these files, and I can give the court the figures on that as well.
Yep. What's the restitution amount?
All right, so the restitution amount on one.
I have down the total of that is $423.83. Does that sound right?
It does
Okay.
sound right, yeah.
Yeah, that's what I have.
That's fine.
And no upfront jail. Okay, and no lacrosse counts 3 and 4. And misdemeanor file. And district court. All right. Okay. All right. Anything else to add to that, Ms. McClure?
No.
All right. So, Mr. Norton, why don't you sit up there for me? Because you look like you're laying down. Thank you. Want to raise your right hand for me?
Yep. Yes.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes. Yes, Your Honor.
All right. Thank you. Can you state your full name for the record?
Daniel Philip Norton.
All right. So, Mr. Norton, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, retail fraud, first degree, second or subsequent offense, which carries a maximum penalty of up to 5 years in prison and or a $10,000 fine, or 3 times the value or difference in price of property stolen, obtained, or attempted to be ever attained, whichever is greater? So is it your intention to plead guilty to count 1?
Yes, Your Honor.
All right, and is it also your intention to plead guilty to count 2, police officer, first responder, assault, resisting, and obstructing, which carries a maximum penalty of up to 2 years in prison and or a $2,000 fine? So is it your intention to plead guilty to that count as well?
Yes. Yep.
All right, are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he has given you?
Yep, I do.
All right, so there has been an agreement on the record between the prosecutor's office and your counsel that there will be no upfront jail. But other than that, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence. Is that correct, Ms. McClure?
That's correct.
Mr. Dagger Margosian?
Correct, Your Honor.
And Mr. Norton, is that correct as far as you are aware?
Yes. Yep.
All right, Mr. Norton, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at that trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Mr. Norton, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes. Yep.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right.
Yep.
Do you need to meet with Mr. Lowe?
Please.
All right, will you radio
Yep.
down or
Yep.
go down there or whatever? Okay. Mr. Norton, do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms or conditions of bond, and the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So, Mr. Norton, do you understand, while you're out on bond, if you commit another offense or violate bond conditions, you won't have a right to withdraw your plea, and I would be able to put you in jail or prison. Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given you, Mr. Norton?
No. No, ma'am.
Mr. Norton, how do you wish to plead to the charge that on or about October 21 of 2025 in the city of Adrian in the county of Lenawee, that you did commit the offense of retail fraud first degree? Guilty or not guilty?
I like to plead guilty to it.
Okay, and would you agree that you also have a conviction on October 8th of 2025 for retail fraud first degree?
Yes.
So you're pleading guilty to a second or subsequent offense, is that correct?
Yeah. Yes. Yes, ma'am.
And then how do you plead to count 2, police officer, officer, first responder, assaulting, resisting, obstructing, guilty or not guilty?
I want to plead guilty.
Okay, has anyone made any threats or promises to you to induce you to plead guilty to these charges?
No.
Do you understand that if I accept these pleas, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. McClure?
No, Your Honor.
Mr. Dagger Margosian?
No, Your Honor.
All right. Has your attorney promised you any other particular sentence or estimated what your sentence will be in terms of probation, fines and costs, or anything else?
No.
All right. Is it your own choice to plead guilty to these counts?
Yes.
All right. So, Mr. Norton, on October 21 of 2025, were you in the city of Adrian in the county of Lenawee?
Yes.
Were you at Meyer?
Yes, I was.
Was Meyer open to the public at the time you were there?
Yes.
All right, and did you steal property that had a value of 200 or more, but less than 1,000?
Yes, I did.
What did you actually, what was it, first of all?
It was a microphone party pack, 2 of them.
Okay, and did you leave with them? Were you able to get away with them?
I did. Yes, I did.
All right. And would you agree their value was over $200, but less than 1,000?
Yes, ma'am.
And your intention was to defraud Meyer of the value of those items?
Yes.
All right. So moving on to count 2, at some point at that day, you came in contact with a William White, who is an Adrian police officer. Is that correct?
Yes.
Where were you when you came into contact with him?
I was leaving Myers and I was getting flipped and I jumped out the vehicle and ran.
Okay, so you were in a vehicle. Was he on foot or driving a vehicle?
It was a foot chase.
Okay,
I
so
jumped out
you
the
left-
vehicle.
Okay, so you left Meyer and you went and got in a car.
I left Myers and the cops found us down maybe 5 blocks down the road and he flipped us.
Okay, did they turn their lights on for you to pull over?
Yes, I wasn't driving, I was a passenger.
Okay, so then the car pulled over?
Yeah, she came to a stop sign and I jumped out and ran.
Okay, and then the police officer ran after you.
You're correct.
And you knew that they were trying to pull you over most likely because you had just stolen some items from Meyer.
Yes.
Okay, so you would agree that you resisted arrest in
Yes.
that?
Yes.
By
I
fleeing.
own it.
Okay.
Yep.
Ms. McClure satisfied.
I am, Your Honor.
All right, has court complied with MCR 6.302 B, C, and D? Ms. McClure?
It has.
Mr. Dagger Margosian?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence other than the court will honor the Killebrew plea that was made. I'm going to refer this matter to the probation department for a pre-sentence investigation. I'm going to set sentencing for, I believe we're using, double check, January 9 at 8:15 in the morning. Mr. Norton, there is an agreement between your attorney and the prosecutor that there would be no upfront jail. So you can appear via Zoom or in person. What would you like?
I'm gonna do Zoom. Be easier for me.
Okay, so that'll be via Zoom. I'm going to put you in a breakout room with Miss Holly in a few minutes. She's gonna give you information on when you need to come in, set up a date, whatever. Make sure when you meet with the probation department, you're truthful about your background, the events that occurred. They'll prepare a pre-sentence report. Mr. Dagger Margosian will reach out to you, but you make sure you reach out to him in case your number changes. And he will review that with you before the day of sentencing, and then we will see you back on January 9 at 8:15 in the morning in person. So, Mr. Dagger Margosian, do you want to join the breakout room?
I don't, but Judge, you just said in person. But
Oh, I'm sorry, via Zoom. I apologize. Okay.
no, I don't need to join the Zoom. Thank you, Your Honor.
Okay, so I'm gonna put Miss Holly and Mr. Where'd you go? Daniel Norton into that breakout room. So you're gonna get an invitation to join the breakout room again, join it. And then when you're done, you can just hang up and go on your way, all right?
Okay, thank you.
Thank you, go ahead and join that. And Mr. Dagger Margosian, thank you for popping back for that. I think you are all set.
I'm all set. Thank you, Your Honor.
Thank you. And Miss Teskey, were you in on what?
I'm here on Cody Lowe, Your Honor.
Okay, all right. And then Miss McClure, are you on Taylor Montalvo?
No, Mr. Bayonetto is, and I have that you guys are going to be having a Cobb's conference.
Yeah, I'm
Is
at
that-
the end of my docket.
Okay, so I can let him know you're ready for that. And then Mr. Sneed was supposed to pop in for Cody Lowe if it's going to be an actual VOC trial. Do we know if it is?
Yeah, probation by VOC trial. I was like, mock trial? I haven't done those since law school. I don't know what it's gonna be, but he's talking to him right now. So, is he ready? You were looking at me, I didn't know it.
Oh, no, he's still down there.
Okay, so it'll be a few minutes, I guess. I just sent a message to Mr. Mont. And then Ms. Teskey, I suppose you've been subpoenaed as a witness?
No.
No, you're a witness. You're a witness,
For what?
right? Cody Lowe, that's a VOC trial.
Oh, yeah, yeah.
She's like, yeah.
Which defense attorney's on Montalvo?
Katerina Dumont.
Is she here?
I just sent a message to her.
Okay, I'll let.
I don't know why I have Rhonda Underwood, but I'll find out. Rhonda Underwood.
Yes, Your Honor. I'm here with news on Mr. Norman, Your Honor.
Nice. Okay. Ms. McClure. So we are going to go back to the matter of the people of the state of Michigan versus Amir Norman, file number 24-21913FH. Ms. McClure, I think you're still with us, but what is your news on Mr. Norman?
Well, Your Honor, thanks to my crack staff, we got in contact with Mr. Norman's mother, who assured us that Mr. Norman continues to reside at the Walworth, that's WALWORTH County Jail in Wisconsin. The number is 262-741-4510. My staff was able to call and confirm that, Your Honor. He has not
Okay.
been released.
Walworth County Jail in Wisconsin. All right,
Judge,
so,
Judge,
yeah,
sorry, I'm looking back at emails and it looks like that sheriff's office did confirm they would zoom him in. I don't know if it's a time difference or anything like that, but just so you.
all right. So I will quash the bench warrant, Ms. Underwood, and I will set this over to December 3rd at 8:30 in the morning. And we will try to get him to zoom in, all right?
Thank you.
All
Have
right.
a good
thank-
day, everyone.
You too,
Hey,
thank
Mira.
you.
Who was that on, Your Honor?
Oh, Mr. Norman, we've been able to verify he is at the Walworth County Jail in Wisconsin. Miss Adams said, going back through the email chain, we did have verification that the county deputy, whatever, was going to zoom him in and they didn't. So I'm gonna set it, I quashed the bench warrant, I set it for December 3rd at 8:30 in the morning. And we will try to get him to zoom in again.
Okay, because the email that Miss Cates got from our office was that he was released on November 6th.
Walworth,
I don't
or
know.
is that,
It just said Wisconsin. Jail
I
in
don't know.
Wisconsin. Yeah.
Well,
I don't know either.
catch him some point, so,
Okay.
all right.
You won't have these below, right?
Is he ready?
I can just tell Justin when it's ready.
Yeah, when he's ready, he can. All right, so Mr. Mott is finishing his sentencing right now, and we'll zoom in. So I'm going to take Miss Spade and step off the bench for just a minute. Stretch our legs. Oh, Miss Spade.
Sounds like a plan.
Huh?
Sounds like a good plan.
Sarah, do you know if Loa is going to be a full hearing?
Just so you know, we're live on YouTube.
I don't think so.
Okay.
We have a seat right here. Your troops next to you. And so before they turn, the judge wants you to stand.
Mr. Bayonetto and Mr. Mont, I'm going to bring you into a breakout room, okay?
Thank you.
Oh, I'm so hungry. What else was that? Katie. Oh. How do I join that? Oh, there we go. Duh.
Spade, how are
Hello,
you?
Mr. Noe, fine, how are you?
Good.
That last hearing you were on yesterday, what, we could hear you so much better,
Okay.
much better.
Well, I got it. I got a new mic yesterday.
Did you?
Or today,
It
actually. I
just,
just used
it
it
just
today.
sounded, before, it sounded like a
Well,
barrel.
I'm sorry.
But-
Because I use a different device.
Oh,
I bought a
gotcha.
different, I used my, so I like my Zoom setup a lot. I think it's really cool because I can have the
Good.
client on the screen, I got me on the screen.
Yep.
I do all of the audio goes through my system, so there's no feedback. I love my Zoom system.
Good.
And like, well, I don't mind sitting next to my clients like this.
Yeah.
And my office quarters are a little tighter.
Yeah.
So I like to have them on a separate screen.
Right.
It's just so much easier. And I
Sure.
have my notes up on my screen. It's so much easier.
Good.
So that microphone not working is really messing with my vibe.
Yeah.
Because
Yeah.
I have a I love my Zoom system.
Yeah.
My favorite
good.
overseeing. And I
Good.
mean, like, for example, like Mr. Raines, he'll have to like move the screen back and forth with his clients. It's fine.
Yeah.
But that, I don't know, I like my system.
Well, good.
I ordered, so I remember I had issues like, I don't know, early fall with my mic, remember? So I ordered a new one. Well, this new one is that I had just in it, and I missed my return window by about 72 hours when it started
Oh, my
malfunctioning.
word.
It's almost like they did that on purpose.
Yeah.
I can't prove that.
Yeah,
But
right.
I swear it's not working 72 hours after the return
Yeah.
window
Oh,
closed.
my gosh.
So I got a new one.
That's not good.
I had to hear this word with Judge Olsen, and I got no complaints, but
Good.
it's annoying.
Morning, Mr. Arton.
Morning. Morning, Doug.
Charles, how are you doing?
Good, how are you?
Good, thanks. Nice win last night.
If they can keep it up, if they can keep playing the whole season, it was the whole game. They didn't have not a bad whole entire thing. It was awesome.
You said one shot that Tang made on the corner.
It was beautiful. Yeah, it was amazing. We played it. And against a good opponent.
Yeah.
It was really. But you know, so early is hard. I don't want to get stuck in that trap so early.
Yeah, but not gonna get worse, unless somebody gets hurt or something. But yeah, I mean, they're not gonna get worse. They're gonna get better.
Theoretically, yeah. That's the goal. They do call him Mr. Marsh for a reason.
Hey, Joanne, did you guys get done with Sam?
We did. Thank you.
Well, my sister was good. But
All rise, please.
All right, Miss McClure, you're the prosecutor and Mr. Lowe. Is she a prosecutor, Mr. No?
I don't know. They never tell me.
And are you, is Philip still going or you guys have an agreement? I thought I heard.
Or
Philip's at 11. Aren't you on that one? No, it's Mr. Rain. Sorry. Never mind. So this is in the matter of people of the state of Michigan versus Cody Lowe, files numbers 21-20527 FC, 23-21347 FC. I have Ms. McClure appearing on behalf of the people, and I have Cody Lowe being represented by Charles Noe. This is the date and time set for a probation violation trial. Mr. Noe, how are we proceeding today?
At this time, Your Honor, my class will be an employee.
Okay. So let me grab his files. All right, so, Miss Holly, the Montalvo file is done. Ms. Teskey, does she need to stay or are you going to stay for the plea on Mr. Lowe?
No, I don't need to stay for that, but did you, Claude, Howard, and I had Matt Coaster? Are those done?
Mr. was adjourned, by the attorneys. I think Miss Adams said December 17 at 8:30. And what was the other one?
Howard, Claude Howard. It was Jim Daly's case.
Preliminaries, it was waived. I don't have a date yet.
All right, that's it then. I'll take off. Thank you.
Okay, thank you.
Yep.
Let me get back here. Hold on.
Judge, while we're waiting, I have written down, there's 2 VOPs on each file.
Yep, I'm looking. I have a September. Okay, so I'm looking back because I know we have a couple. So I have a violation of probation from October 1 of 2025. And then there is one before that for September 17 of 25. Is that correct, Ms. Teskey?
That's correct, Your Honor.
Okay, so Mr. Lowe, want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Right, want to scoot up a little bit, and Mr. Noe, we're loud as attorneys, so why don't we slide that mic in front of Mr. Lowe?
Sure.
All right, so Mr. Lowe, we are here today. It is the date time set for a VOP trial and a violation of probation. You have retained Mr. Noe as your attorney. Are you satisfied with Mr. Noe as your attorney and the advice that he's given you?
Yes, Your Honor.
And Mr. Noe has stated that it is your intention today to plead guilty to all of the violation of probations on each file. Is that correct?
Yes, Your Honor.
All right. Now, do you understand on file number 27, on file number 21-20527 FC, on that file, you had pled to assault with intent to do great bodily harm less than murder or by strangulation. So the maximum penalty, if you plead to these violations, could be up to 10 years in prison. Do you understand that?
Yes, Your Honor.
All right, and then on file number 23-21347 FC, on that file, you pled guilty to a controlled substance delivery manufacture of heroin and or fentanyl causing death. Let me see. Oh, no, he pled to count 2, Miss Walsh. Right, the delivery less than 50 grams.
He did, Your
Yes.
Honor.
Okay, so do you understand that carries a maximum penalty of up to 20 years in prison?
Yes, Your Honor.
All right. Now, do you understand that you do have a right to contest this violation of probation charge and to have a trial on it? And in fact, all parties are present and ready to go if you had chose that. Do you understand?
Yes, Your Honor.
Do you understand that throughout that trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes, Your Honor.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear. Do you understand all of that?
Yes, Your Honor.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, Your Honor.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes, Your Honor.
All right, so Mr. Lowe, on both of these files, the first violation dated September 17 of 2025 alleges that you committed a technical violation and that you were ordered to report to probation as often as required, and that you failed to report on September 16 of 25 on your routine report day. And you were also ordered to complete and enter and complete the adult recovery court program and comply with drug testing requirements on the color brown, and that you failed to submit a drug screen on September 15 of 25 as instructed. So do you understand that's the allegation on the September 17 of 2025 violation of probation?
Yes, Your Honor.
And how do you plead to those two counts? Guilty or not guilty? Guilty? Say it again for me.
Guilty, Your Honor.
I spoke over you, I'm sorry. All right, and then we have the October 1 of 2025 violation of probation, which alleges that on March 1 of 24, you were ordered to report as often as required. Okay, and so they added a count to the September 17 plea. No, wait a second. So there's the September 16 failure to appear and then failure to drug test. So in a way, Ms. Teskey amended it. So there is the count one, you failed to report on September 16 of 25. And then count two is that you're ordered not to use any illegal controlled substances. And it's alleged that you tested positive for alcohol. You're not supposed to use alcohol either. Morphine or benzodiazepine on October 21 of 25, admitting to heroin use 6 days prior to that date. And then count three, you failed to comply with drug testing requirements on September 15 or any time thereafter. So they're kind of the same, but they added to it and amended it. How do you plead on the October 1, 2025 violation of probation?
Guilty, Your Honor.
All right. Do you understand that you're giving up your right to have your trial today, as we've already explained to you?
Yes, Your Honor.
Has anything been promised to you to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty?
No, Your Honor.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty to these counts?
Yes.
All right. So, Mr. Lowe, on both of these files, how do you plead to the September 17, or I'm sorry, there was request and summons for probation violation that's dated September 18 of 2025. That's the date it was filed. On March 1, when you were placed on probation, you were ordered to report to probation as often as required, right?
Yes, ma'am.
And then you were supposed to report on September 16 of 2025. Is that correct?
Yes, Your Honor.
Did you report that day?
Don't believe so.
Okay, did you submit a drug screen the day before?
No.
But so you were supposed to test on the color brown. So Ms. Teskey, that would have had him having to test on September 15, the day before report day. Is that correct, Ms. Teskey, on a Monday?
That's correct, Your Honor.
So you're supposed to drug test on September 15 and report on September 16. Did you do either of those?
No, Your Honor.
Okay. And is that because you were positive in using?
Yes, Your Honor.
Okay. And then we'll move on to the October 1 of 2025 violation of probation. Again, you were ordered not to use any illegal controlled substances or alcohol. On October 1, you did submit to a drug screen and you tested positive for alcohol, morphine, and benzodiazepine. And you admitted to heroin use 6 days prior. Is that correct?
Yes, Your Honor.
Okay. And that's because you had used heroin 6 days prior.
Yes, Your Honor.
And consumed alcohol.
Yes, Your Honor.
Okay. Then, okay. And that again has the failure to test on September 15. So it was amended to add count 2, right, Ms. Teskey?
It was, Your Honor, but this violation originated from August. He received a violation for being out of state without permission. And so I think we need to arraign him on, or have him plead guilty to that one as well, because he hasn't pled on that one.
What day was that filed? Let's see.
August.
August?
Yes, that's, hang on a second. I'm trying to pull all this up.
See if I can find it.
It was violation of the law and by leaving the state.
Let me see, because I got October. Oh, here we go. I got it filed on 9/11. Let me go back.
Okay, that sounds about right.
Okay, I'm sorry, Mr. Lowe. There's another one. So on September 11 of 2025, Ms. Teskey did file a request and warrant for probation violation, which alleges that you were ordered not to leave the state of Michigan without permission when you were placed on probation. And on August 3rd of 2025, you left the state of Michigan and you were in Ohio when you were pulled over by the Toledo Police Department for speeding and a seatbelt violation. And then count 2, you were actually given a citation for speeding and not wearing a seatbelt on Lucas County, in Lucas County, Ohio on August 3rd of 25. And that is a violation of criminal law, which is a violation of your terms of probation. So do you understand those allegations against you?
Yes, Your Honor.
Okay.
I wanted to address something on those particular allegations. Certainly count 1, I certainly get.
Has he not gone to court on count 2?
Count 2, he paid the tickets, but I've dealt with this issue before, not before this court, before another court. These are civil infractions. They're not criminal offenses. So I know my client wants to plead guilty, and I wanted to clarify on the record that I can't, I know it's maybe not necessarily a huge deal in terms of what happens on the ultimate outcome of this case, but those are, I pulled up the Ohio code. Those are civil infractions, not criminal offenses. And so I don't know how we can legally plead guilty to that when I don't believe that those are criminal offenses.
All right, so Ms. Tuskin tried to pull up his probation terms. Those are citations versus criminal. I'm gonna look at it.
But the count 1, he absolutely left the state. There's no dispute.
I will take a plea on count 1, but not count 2, Your Honor.
Okay.
That works for us.
So we'll dismiss count 2. So is it your intention to plead guilty to count 1 for leaving the state of Michigan?
Yes, Your Honor.
Okay. So one of the terms of your probation is you couldn't leave the state without our permission, right?
Yes, Your Honor.
So you went to Toledo on August 3rd, is that correct?
Yes, Your Honor.
What'd you go to Toledo for?
It's going to work.
Going to work. Okay, so here's the thing. You're on probation. You're not allowed to leave the state. You don't wear your seatbelt and you speed. Is that correct?
Yes, Your Honor.
Like, did you just have a flag saying, pull me over now because I want to go to jail?
Yes, Your Honor.
Okay. All right. All right. Anything to add to any of those, please, Mr. Noe?
No.
Okay. Accept the pleas. They've been given understandably, voluntarily, and accurately. He has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for a pre-sentence investigation.
Judge, my client would prefer immediate sentencing if that's possible.
I think because of the nature of the charges, I don't know if we can sentence immediately, Ms. Teskey.
No, Your Honor. I mean, he can waive his right to an updated violation report, but
I'd rather not in this. I'd rather not in this case. There is a victim on one of the charges, so I have a hard time with that. It's next week. It'll be next week. We'll get it done right away.
Next Wednesday.
Miss Adams, let's see, Miss Adams has a BOP sentencing. Miss Adams, yeah, it'd be next Wednesday at 8 AM.
That's fine, that's fine. That's fine.
All right, we'll set this for sentencing November 26th at 8 AM. You know, these violations break my heart a little bit because Mr. Lowe was a longstanding member of recovery court and doing relatively well. So, you know, I do want thought to go into this. Okay.
Yeah, thank you, Judge. Can we set that? I would like my client in person, so that's.
Okay, so we'll make that in person. All right, so Mr. Lowe, Ms. Teskey will probably meet with you and go through some things with you. She'll prepare the report. We will get a copy of that to Mr. Noe, and he will review that with you before sentencing, all right?
Okay, thank you.
All right, thank you, Mr. Lowe.
Yeah, I'll talk to you soon.
All right, Ms. Spade, we have an 11 o'clock. I gotta, okay. Off the bench.